criminal traffic violation should be checked. And there should be also the box for no firearms or CPL checked. And then for a period of 24 months, and I'm in agreement with those
Okay, excellent.
conditions.
Thank you, Mr. Rio. Okay, Mr. Koch, good morning. You had a chance to go over this document with your attorney? Okay, do you understand the rights you're giving up by entering into this agreement? You understand that this is an agreement between you and the city, and it's going to last for 24 months. As long as you successfully comply with each one of these conditions, then the city is going to move to dismiss this charge of violation of court order against you. You understand that? Now, if you fail to agree with each one of these conditions, this will come before the court. The court will look only at the police reports to determine your guilt or innocence. Are you aware of that? Okay, you're aware of giving up your right to a trial? Okay, then I will go ahead and sign off on this. Those conditions are, as Mr. Rio stated, the $200 administrative fee you need to pay, no criminal or criminal traffic violations, no firearm possession or dangerous weapon possession, do not possess or apply for a concealed weapons permit. Is that your understanding as well? Okay, now the last thing we need to do is determine what the payment plan will be for that $200. How much do you want to pay a month on that? Okay, pay in full today. And we'll set a review hearing for 2 years. That will be the next time we check that this matter comes before the court to determine whether or not this is appropriate for a dismissal, okay? And Mr. Rio, I'm just saying approved via Skype.
Please, Your Honor.
Okay. Can I get a review hearing date for 2 years out, please?
How about, what date do you do those on, Liz, on Tuesdays?
Yes.
September 6th, 2022. September 6th.
Of 2022, and I'll write it on right here on his agreement as well. So, okay, do you have any questions? Okay, good luck.
Your Honor, one last thing.
Sure.
If you would tell him that that's the only notice of that court date he's going to get. So just to remind him that he needs to put a note in his calendar where it needs to show up on that date.
Did you hear that? Okay.
Thank you.
Yes, and let the court know if your address changes as well.
Pasco versus Eric Agard, 9Z0724577.
Okay.
I'm heading forward a statement of defendant on plea of guilty. Since Mr. Rio is not present in the courtroom, the court would like to confirm with Mr. Rio that the recommendation I listed is actually the prosecutor's recommendation.
So it's going to be, Your Honor, it's going to be city's motion to amend to destruction of property, non-domestic violence.
Okay.
And the recommendation is 364 days in jail, 363 suspended, credit for 1 day, a $500 fine, 2 years probation, $200 probation cost, and anger management.
Okay. And are we doing a no contact order?
I don't believe there's one in place, Judge, and so I'm not asking for one to be put in place.
Okay. Okay. Good morning, sir. I'm great, thank you. Have you had a chance to go through this guilty document with your attorney today?
Yes.
Any questions about the rights you're giving up by pleading guilty?
No.
Okay. Now, hold on a minute. Okay, now the city's moved to amend this charge to remove the domestic violence tag. Is that your understanding as well?
Yes.
Okay, and that's what you're pleading guilty to. Okay. Now the prosecutor's recommendation is, as he stated, It's for 1 day in jail, suspend 363 days of time for your period of probation, credit for that 1 day. So you would not need to report and serve an additional day. What you need to understand about the suspended 363 days is that if you violate probation in any way over the next 2 years, you could have any amount up to that time imposed, okay? $500 fine, you would be required to do an anger management class. There would also be some additional court costs, including a $50 jail cost, a $43 conviction filing fee, and the $200 for probation, okay? Now, you also need to understand that the court does not have to follow that recommendation. I could impose the maximum allowed by law. Are you aware of that? Has anyone made any threats or promises to get you to plead guilty today? And by pleading guilty, you will owe fines in this court. Do you acknowledge those fines and can you pay for those? Okay, your statement is on July 28, 2019 in Pasco, Washington, I kicked a door causing damage to property. Is that what happened? Okay.
And Your Honor, I needed to say that it wasn't his own property.
That was not my own. I'm going to add that language to further define that property, that you did not own that property, okay? So we meet our statute of what's required here.
And does he agree that it wasn't his own property, just so the record reflects that, please?
Okay,
Thank you, Your Honor.
you're welcome. Now, Mr. Rio, are you signing these or wanting me to write?
Just write approved by Skype. I think the record's clear that I'm on the record with that approval, Judge.
Okay. Okay, sir, I will find that you're making this plea freely and voluntarily. I will accept your guilty plea. I will also follow the prosecutor's recommendation at sentencing. So we will impose the 364 days, suspend 363, give you credit for that 1 day, okay? You're welcome. Your fine is $500. Of costs, we're gonna go over that in just 1 minute. And you can tell me how you want to pay those. Let me add them all up here for you. 500 for your fine, probation will be 200, jail cost will be 50, and that filing fee is 43. Oh, you got a new calculator. Thank you, better than yesterday's.
$793, I believe.
That's what I have as well, thank you. You going to pay it in full today? Okay.
Let's just say within 30, Your Honor. So,
Sure.
If you get stuck in traffic and comes tomorrow, back here.
I could just go into my car, get my wallet, come back in here and take care of it.
You sure can.
I'll show you where this goes on.
Okay, so I did not set you up any payments, sir. You can pay that in full. I did say within the next 30 days. You're welcome to do that today, whenever you'd like, okay? Let's see, now the terms of your probation will be 24 months, as we talked about. You will be required to do that anger management class. I also am gonna set up a meeting with probation in the next few weeks. We'll get you that date before you leave here today, okay? And they're doing Zoom calls. I'm not quite sure how they're going to, in what capacity they're going to meet with you, as things are always changing. A call appointment, a phone call?
And then it could go different.
Then they'll go from there, okay? So what we will hand you today is a date and time for you to connect with probation. Make sure you make that appointment. If you don't, it could be a probation violation, okay? Okay. And we'll put that on the record, and I like to put that on our judgment and sentence as well, okay? So what's that? Excellent. Do you have that date and time?
Yes, next Monday's date would be, oh, yeah, how about the 15th or the 14th? Monday, the 14th.
September 14th, and that's for him to call?
Yes.
Is there a certain time?
It's got the date, the hours on the, so it's be before 4 p.m.
Before a certain amount of time, because I'm in school.
Okay,
So it just has to be before 4 p.m.
okay. Does that work for you?
Yes.
Okay, wonderful. Okay, your other conditions of your probation would be no criminal law violations, keep your address current with the court at all times, get that anger management class done, maintain good contact with probation. Do you have any other questions? Okay. Okay, then I'll hand you these documents down. You can sign that judgment and sentence. And you'll be on your way, okay? You're welcome.
Yeah, it was amended to non-TV.
Correct.
That concludes my matter, other than the continuance, which will be pressed.
Okay, excellent. Thank you.
Do you need something to call, Jed?
Well, I have, let me check and see. You know what? I'm just gonna go through these on the record, I guess, until we get somebody. I have a Gabriel Alvarez Carranza. You see a promise to return. This is a Mr. Rutt's matter. Promise to return November 23rd.
Okay, thank you.
Oh, you know what? This. Okay, Mr. Alvarez is present and needs an interpreter, so we're gonna get him set up here real quick. Good morning, sir. Are you Gabriel Alvarez? Okay, excellent. And you were here, it looks like when you came in this morning, did you apply for an attorney?
What happens is because I paid a lot of money, I wasn't able to retain an attorney.
Okay, excellent. It looks like we are appointing Mr. Rutt to help you out and be your attorney, okay? You'll get some information on how to contact him. And I'm gonna give you another court date of November 23rd at 8:30 in the morning. So if you can give Mr. Rutt a call before that next court date, and then make sure you're here on the 23rd as well, okay? Okay, do you have any questions?
No, it's fine, thank you.
Okay, you're welcome. We'll see you on the 23rd. You're welcome. And I have Pablo Bucio Montiel. Good morning, sir.
Good morning.
Okay, let's see. It looks like you have applied for an attorney and you do qualify. So we will appoint Mr. Ty Libert to be your attorney, okay? We've gotten some information on how to contact him. Please do that before the next court date. And that next court date will be November 23rd at 8:30 in the morning. Do you have any questions? Okay, we'll see you back on the 23rd. You're welcome. Mr. Jameson, I'm just gonna call some resets, so jump in whenever you're ready. Yes.
Arturo Navaris. Is that the one you have in your hands? He's there.
No, but he might be on this pile. Let me check.
Is it that folder laying down?
Yes, it is that one.
Yeah,
then.
he's incarcerated.
Oh, let's call him then. Does he have an attorney?
We appointed one.
Oh, excellent. Are you Arturo Navaris? Good morning.
Good morning.
Okay, sir, it looks like you've applied for an attorney and you do qualify. So I'm going to appoint Mr. Rutt. Mr. Rutt to be your attorney.
I don't have anything to find. I'm guilty. I just want to be sentenced and for your honor to give me a fine and then to be allowed to be released after that in order to be able to find work. Well, I do have a job. I just need to be.
Okay, what you've been charged with, sir, is driving while license suspended in the 3rd degree, driving under the influence, and operation of a vehicle without ignition interlock. These charges carry significant jail time and monetary penalties. So I understand that you want to get this done and over with, but I also want you to make sure that you are doing what's best for you and not pleading guilty before you really want to. Does that make sense? I don't want you to regret that, sir. There is a way you could. Let me double check and see. Just 1 minute. So, sir, I'm looking at 1, 2, 3, because this is your 4th driving under the influence charge in the last 12 years, you would be looking at significant jail time. And you would not be released today, even if you pled guilty. So I think the best route is to keep this attorney assigned to you. You'll get some information on how to contact him. Go ahead and give him a call. And he'll be with you on your next court date, which will be September 28th. Okay?
Judge, is there a reason we can't do it like the 14th of September, just to try to get this along a little earlier?
I'm more than fine with that. I always, even though I know we load our dockets that way, I would much rather have our cases.
I just think it's better on this one particular case to try to do that.
I agree. September. Oh, that's a Tuesday docket. Let's change it to the 14th, please. I know it's a big docket, but let's do it. Just so we can get Mr. Navarez in front of his attorney and questions answered. Thank you. Yes. So the 14th, okay, sir, that's the next possible court hearing we can give you. Yes, yes. 2 weeks.
So when will I be able to talk to my attorney?
Well, you'll have his phone number, so you can give him a call whenever you can work that out with the jail. He will likely not have your file or any documents for probably 4 or 5 business days at the soonest. It takes a while for that to transfer to him. So I would give him a call next week.
Next week, not this week.
Yes.
So from next Monday, I'm
Are you asking if you're in court next Monday?
to call the attorney next Monday.
Sure.
or after. Sí, thank you very much.
You're welcome. Okay, I see Michael Torchia. This is an agreed motion to continue. To December 8th.
And I'm in agreement with that research.
I don't know that it necessarily matters all that much, but are we noting FTAs, or there's no language officially waiving on that motion? Do you have a preference of how we?
Well, it's an SOC revocation, so I think it's still waived, but by agreement, we've FTA'd and reset the case, so.
Okay, that will be reset to December 8th. then.
Thank you, Your Honor.
Oscar Del Valle. This is a waiver resetting this matter to November 3rd. Just Jose De Leon, a waiver resetting this matter to November 3rd. Roberto Garza, an agreed waiver resetting this matter to November 3rd. Austin Bitten, an agreed waiver resetting this matter to October 20th. Miguel Contreras Cisneros, an agreed waiver resetting this matter to October 13. Victor Dominguez. 2 clause numbers. Agreed waiver resetting both of these matters to November 3rd.
What What was that name again, Judge? Sorry,
Dominguez?
Dominguez. Thank you.
Next is Ernesto Garcia Madrigal, an agreed waiver resetting this matter to October 27th. I have Alejandro Santoyo. This is a promise to return November 3rd.
And that was by agreement, Judge.
Okay. And I have a Jose Saldana Chavez, a waiver resetting these. Let's see, I have two matters. I'll make sure both of them get on this waiver, resetting this to October 6th.
And that'll make this case 2 years old. So I told Mr. Roach that's kind of the end of the road even for him.
And 6. Oh, I see. That was just the infraction. Okay, those are my waivers that I have so far.
All right, Judge. Luis Camacho, please.
Okay.
City's motion to dismiss for compliance.
Okay, and are we dismissing both? Cause
Yes,
numbers?
please. Yes, please.
Okay, I'll write these orders up. Is this SOC compliance?
Yes, please.
Paid in full. Mr. Rio was dismissed.
What's the last name on that one?
Victorino.
I don't. Mr. Rio, Gabriela Victorino has paid in full. I'm seeing the receipt on that.
That would be city's motion to dismiss then, please, Judge.
Okay. These two I can give you. Thank you. And that was an SOC as well, correct?
Yes.
Victorino?
Yes, correct.
Okay, anyone else, Mr. Rio?
Yes, Your Honor, we can call Jesse Uli.
Okay.
I believe that's going to be a failure to appear, and city's going to request a bench warrant.
Ooh. Looks like we got our mail returned. We sent it to the last known address we had on DOL. We've also sent notice to a Jadwin address in Richland.
And Your Honor, there's a new charge and a new conviction. I'm just pulling it up right now. So there is a new pending Richland charge from August 3rd, a theft charge, and there's a driving license suspended. So both of those would violate the conditions of this. The
Okay.
city is going to ask for a warrant, please.
I think based on that, we'll issue that warrant. Do you have an amount you're requesting?
500 bond or cash, please.
Okay, that warrant will issue.
Thank you. Eric Schumacher. That's Mr.
Okay.
Jameson's case, but I'm agreeing to dismiss for compliance. I'm sure Mr. Jameson doesn't have any complaint about that.
Okay. Okay, that will be dismissed. Jacob
Hall.
Is there a no contact order on that one?
I didn't
On the
see one,
Schumacher.
Judge. Let me go back and see if I can.
I see one in the file, but looks like an old one that was not actually entered. I just want to make sure we didn't.
Let me pull that up, Judge, real quickly. I do not show. I show it was terminated according to the docket. And I can give you that date.
Okay.
Looks like August 28th of 2018, the court terminated that
I see.
with entry of the SOC.
Okay, excellent. Thank you for checking on that.
You're welcome. Jacob Hall.
Okay.
Is Mr. Hall answering, Judge?
Jacob Hall? No response in the courtroom.
Your Honor, I show Mr. Hall has an active bench warrant out of Walla Walla District Court on a driving license suspended third. This is an assault domestic violence. I'm going to ask you to note the FTA issue a bench warrant. The city's going to request 1,500 bond or cash.
There was no one in.
No one in the hallway? Thank you, Phil. Okay, Mr. Hall is not present this morning based on active warrants on other cases and the nature of this charge. Him not being present today, I do think that's appropriate. $1,500 cash or bond warrant.
Did we do Travis Kristen?
Nope, not yet.
So that's city's motion to dismiss for compliance, please, Judge.
Okay, that matter will be dismissed.
Is Mr. Dickerson, LD Dickerson back, Mr. Green?
LD Dickerson?
Mr. Redfield seen a picture of that he had paid.
He has paid.
He had the receipt on the email on his phone.
Perfect.
Showed me he had a paper.
Okay,
Perfect. That's what I needed, Judge. So dismiss for compliance based on the payment.
okay. Okay, that matter will be dismissed.
What do you have left, Judge?
I have a Gerardo Camargo Jimenez, it's a 12-month SOC, it looks like.
City's motion dismiss for compliance, please.
Okay, and then I have a Jose Sanchez, Mr. Jameson.
Good morning, Your Honor.
Good morning.
Your Honor, Mr. Rio and I spoke about this client of mine yesterday, and Mr. Rio informed me that there was a new allegation that I was unaware of, but I did notice was arraignment on Tuesday, September 15th p.m. And I see in my file the amended conditions for release appeared from July 7th. That is not signed by my client, but I do recall him being on the phone because he was sick. So he did call in that day. So I can't verify one way or another to the court if I know he goes to bail, but I don't know if Mr. Sanchez knew of today's court date. I don't think I figured that he maybe assumes his next court date is September 15th. I haven't had recent contact with him for a number of reasons. One, he's a truck driver that Franklin County Superior Court amended his conditions of release to allow him to travel throughout, if I remember off the top of my head, Arizona, California, Montana, Nevada, Oregon, Idaho, essentially the whole West Coast, and somewhat because he's a long haul truck driver. So again, and the other reason my office has been without phones until today. It's been a nightmare. Also with cell phones. I haven't had contact with a lot of clients except via email. So again, I haven't heard from him. So the only thing I could ask for is set it to September 15th, and I'll let Mr. Rio make his record.
Okay, thank you.
Your Honor, he appeared via remote hearing at his last hearing. That's when the court set today's date. The court would have said out loud, your next court date is September 1st. While we can't have people signing remotely, if we're going to allow them to appear remotely, they're going to have to make it their obligation to get here. Now we have a new allegation of another violation. I had that brought in today so that we could do an arraignment should he appear. But last time we were in court, I asked the court to increase his bail because he had an assault second with a deadly weapon charge. The court increased his bail on this case. And now we have another violation of court order from July 28th, which was after his last court date. So from the city's point of view, he needed to appear today. He has not. He's got a new violation. And so I'm going to ask the court to note the FTA and issue a bench warrant.
Okay. And I'm looking at the that amended conditions of release, and looks like I signed that. I remember that Skype hearing and I believe it was via video, wasn't it? If I remember correctly. In any case, I know for a fact we told him his court hearing and his court date. So it's too bad he's not present today. And I think a warrant's going to be appropriate. I understand if his job takes him everywhere, that's definitely understandable. But with this new charge, it's very concerning that he had that assault too as well. So I think that a warrant's appropriate and kind of leaving us no choice rather than to issue that. So I'll go ahead and do that. I know he's on that 25, what did he post? It's 2,500.
Looks like that.
Okay, I'm gonna keep that in place. I'll issue a warrant. Do you have an amount requested, Mr. Rio?
7,500 bond or cash.
Okay. And Mr. Jameson, if you'll let him know that with what we did today, please, and we'll go ahead and keep his arraignment date on the September 15th date, and hopefully we can see and hear from him then.
Thank you.
Okay, Mr. Jameson, do you have anything else? I see it, Lorenzo.
Yeah, not until the 11, but Mr. Rio and I believe we have an agreement.
Sure.
I'm having my client show up around 10:30.
Is over here calling.
I have it. Does he want it?
He wanted to look at it.
Thank you.
Okay, and then I have an Arturo Llanos Barraquin. That's a Mr. Liver matter.
We send the NCO.
Oh. And what time would we have set that for? Oh, that's set for 11? Okay, we'll wait until 11 to see if that requesting person arrives. And then I see a Mr. Roach matter, Emilio Avila.
So Mr. Roach evidently is in Dayton, Your Honor. He's on his way back. He would like to hear this about the time we have the NCO hearings. He wants to argue conditions of release.
Okay. I see. So we'll hold off on that one then. How about our in custodies? Can we handle any of these matters?
Provisional hearing that day.
So
Oh.
if you, this is one from yesterday, if you want it brought back up.
Yes, we need to finish his arraignment.
Yep.
So whenever. Dot said you guys wanted to bring him separate.
So he just needs to,
He was a little volatile
he's here
yesterday. Oh, he's present now?
yeah. If that's something we need to.
Sure, yeah, we can absolutely address
Where
him.
you were at with addressing-
Carl Dickinson? Good morning, sir. Okay, you left yesterday before we could finish your conditions of release and your arraignment. So I had to have you brought back down today so that we can go over this document on the record and I could give you your next court date. If you'll recall, so all I'm going to do today is go over your document, go over your conditions of release. We did appoint an attorney for you. That's Mr. Eric Scott. He'll be there to help you at your next court date, which is set for September 21st. And actually, do you know what I'm going to do is I'm going to set this on the 14th docket as well. This is Mr. Dickinson. I know we talked about some competency stuff going on in Superior Court in Benton County. And I would like to have you with your attorney as soon as possible. Okay, so if we can change his court date to the 14th, that would be awesome. Thank you. I see a copy of those conditions one more time. Thank you. Okay, sir, so the other conditions that we set forth are to not discuss the case with the victim, do not possess or consume alcohol, marijuana, or non-prescription drugs, have no new criminal law violations, let the court know if your address changes, come to all your future court hearings, and I did set that bail at the $250, okay? 250. Okay, we'll see you back on September 14th, okay?
No, hold on.
Thank you. So do you need a recess, it sounds like?
Yeah, it's either
I believe so, Your Honor.
Okay.
Chat's gonna take him down. Either one of
Sure.
those can walk you down before.
No, I'll wait. Take him down first, and then I'll stay up for a minute.
And I'm sorry for my,
You tell me what to do.
Well, I won't be able to walk you down because I'll have to stay with these guys.
Oh, so do you want to walk me down right now?
Yeah, that might. be-
Whatever's easiest for you. Okay, thank you, Mr. Rio.
thanks, Judge.
It's legible. I mean, yeah, it's.
It's just that. But. Schedule? Yeah. But I don't know. Because I did the emails twice. I had to do it like the second time. So I wonder which one you had the first time. Take this down. You only have, we can read mine. Actually. That's okay. So we got. Yours and seal. I want to take. Is it gonna bite it?
Hey, Liz,
Yes,
I emailed you Ray's offers for the in custodies.
okay, I'll go print them out right now.
Thank you. I also emailed those to his email address, but I'm not sure he'll get them. So
Okay.
thank you.
You gotta be pursuing. I mean, the charges, it's all the other side. I'd be writing them a letter.
So you guys stick around here till 11?
No, my guy, hopefully gonna be here at 10:30. Yeah. Oh, anytime now, hopefully he'll be here soon, we can get it done. Okay.
Oh, no. She said, no, I'm not coming back. Who's supposed to do this? I'm not sure. I was going to be sure. I assume it was me.
I can't believe how much he's slacked over the years. Got down for tennis shoes, practically jeans and polo.
He gets away with stuff that I don't know how the heck he gets away with. He's a different cat.
Yeah. I've always disagreed with this provisional attorney or arraignment attorney. That they're not linked to a case. They're not. Because under any standard, the bar association would say they're giving that person advice. If you're giving them advice, they're your client. It counts as a case. Advising, you can't just say, well, I'm not going to do the case, I'm just really advising what you're trying to do. You're their attorney,
Right.
not just a provisional. I never agree with that. God, it doesn't make any sense.
You know, would it be the same though? All they did was, here's the charge. Here's the offer. You can take it or not.
I mean, technically, there would, under that, the prosecutor could do that, because then they're not representing, the prosecutor's not representing, they're just advising what they're charged with and what they're willing to give them. I mean, it's really bizarre. I mean, you can't, I don't think the bar association would say that he's not liable for like misrepresenting if something comes up. I say, well, that's what that attorney told me. I'm not here charged, I was just there. Prove them an error. No, it's a critical phase of the action. So,
Didn't Washington State, they kind of have to provide.
yeah. After Grant County got sued and all that kind of stuff went down. But it's still to call it a provisional attorney.
I don't know. It's not my concern.
Yeah.
I got my own worries. I got worried about stuff I don't need to worry about.
Not really.
No horse.
Not until high school rodeo starts in the fall. We got a long view.
What is it?
Trying to say. My daughter does poles and barrels. And so we'll be going down there for that. But now for this weekend. My wife asked me today, any plans? Well, it's my dad and my birthday. So it's really strange that I was born on his birthday. My daughter was born on my wife's birthday.
On your wife's.
Yeah.
Really?
It's just crazy. I mean, I don't think there's any statistic out there for that, but it's just crazy. But yeah, so Labor Day weekend is always, yeah, so she asked me, what I do. I need to rototill part of the perimeter of the pasture, drag the pasture.
Right.
I gotta work on it. It's not a pressing thing, but I can pull the turbo back off my Ford. It's got a bit of a oil leak. Back turbo seals are mounted on the compact wall. It's just got a little drip that just annoys me. I don't want to hear first. Wife and daughter use it a lot. It's a tow rig. So I just want to fix that.
You want it reliable.
Yeah, it's gonna be that's gonna be a full day, 2-day job. So I'm thinking time when I can start on that. But also got work in the buildings to do. I was down there last night cleaning out the drive-through. There's a bunch of landscape rock in it. But always something.
Yes. It's funny. Get over it.
Yeah.
But it was crazy.
Oh, God.
Their birthday week.
Oh, God, yeah.
I always kind of joke and say, why should I celebrate the day? What if you do the year before? I know it's just going to get that much harder.
Are you talking to me?
And I just love
I have my-
so graceful.
I have my headphones on.
I need to redeem thing about it.
Yeah. That's true.
We're coming back from Portland area. My cousin's kid got married, going to get out of the stuff of cafes, the bench seat or whatever. And the waitress turns around. Are you all right? Just getting out.
Yeah.
Have you seen my water?
Yeah.
Funny, you get around the guys. You've seen those movies when you're 20s or the whole time you get around what ails.
Yeah.
Crap, when did that come?
Right.
At the wedding, you know.
Yeah.
I always go with it. Yeah, I had to have my shoulder operated on this time.
Yeah, my buddy was helping me last night took a tractor down there. So that helps obviously a lot, but we still had to shovel as we get down towards the end. We still had to shovel the broken basalt rock, landscape versus basalt rock in the bucket. And he did a lot more than I did because I was operating the tractor and I'd hop on the charts.
Hey, Mr. Green.
Yes.
So, can you hear the background noise around me?
I can hear something. Maybe.
But it's not disturbing or anything?
Just your voice.
Well, there's that. So I came here because they were doing construction around my house, tearing up the road and stuff. And so it was really loud. And of course, now the landscaping people are here at our office doing mowing and weed eating. So, you know.
No, I don't hear it.
All right.
But that's not, someone else might hear it, but.
Well, your ears are barely past muster, but
I'm old, yes.
All right, thank you.
You got it, Toyota.
So we get back to my house and get out of the winds. That's what I was just like, yeah, shoveling broken salt rock isn't as easy as it used to.
Ain't that the truth?
Because it's just, once you put it in place, around those shovel bounces off everything straight. I decided I was better off to put my boots on, just lock on, push the ground with my legs, dragging. Shovel that shit.
Yeah. We did some, mainly had my voice do it. We don't have to do much. You guys can move that rock.
Yeah.
Usually once I get it going, then I'll get them to do it.
Yeah.
Get them there. It's amazing. Get a little bit of desserts, but I'm just tired.
Yeah. Yeah, my old saying is, if you ever find yourself bored, you need to buy a house or buy property. You're not gonna get on the board. And I'm just the type that, you know, I can walk from my house to the shop, or the back barn. I see crap, I go pull it, instead of spraying it. I thought I pulled that one yesterday. It's bad.
Yeah.
It's just always something.
Got it just probably COVID, so I want to be in hospital. I had to come back to work to get a rest.
Oh, yeah. Yeah.
Then, I don't know if that's the way these kids want their careers, so he was kind of a person.
Oh, yeah. How old's your daughter that just?
24. She didn't have any symptoms or anything. She just around the 4th, they had a party. Cousins. He just had stomach ache or whatever. And his she went to go get tested. She tested positive. And I get a text when I'm standing in the courtroom. Just us.
Yeah. Does she live with you or?
No.
Oh,
But she just been at her house.
sure.
Barbecue or something.
Oh, yeah.
And that's I won't be that guy.
Yeah. What, so I didn't ask Mike yesterday when I talked to him, but he told me that he's quarantined, so who did he get exposed to?
Somebody over, I think in Benton County said,
Hey, Randy.
Yeah.
So I was standing in Judge Osborne's courtroom,
he's dropped on our conversation.
right?
Yeah.
And I was, we were doing the, trying to remember the warrant recall docket.
Uh-huh.
And this gal walks in and she sits down behind me and she's coughing, but you know, not anything huge. And then all of a sudden she comes up next to me, starts coughing really like a big chunky cough
Oh, geez.
where you can hear junk coming up.
Oh, yeah.
And then she's like, by the way, I have COVID. So can I get out of here fast?
Oh, my God.
And we're all like, well, the signs on the door say don't come in at all.
Yeah.
Well, I thought I had to be here. So anyway, so, but I was the only one close to her. Everyone else was behind glass, right behind the plexiglass. So I thought it would be best for my partners, for Jim in particular, that I stay away for a while till I figure out if I've got it or not.
Exactly. That sounds
So
like, that sounds like contempt of court to me.
it was something for sure. But it made the judge very angry. Let's put it that way.
I can imagine from Osborne.
Yeah, he was pretty angry about it. So
My client's here. I'm gonna go talk to him and see if we can get the judge it's done.
All right.
I took and turned him up just a little bit on that. You having a tough time hearing? That little speaker?
Well, I'm sitting right here and I can hear him when he's,
So can you guys hear me better now?
oh yeah.
I just took and turned the speaker up a couple.
Oh, okay.
On the judge's desk.
Perfect. Is Mr. Roach arrived yet?
No.
Okay.
We do have Cussies in here.
Is Mr. Huey arrived yet?
No. Just letting you know so you don't say anything you didn't want other people to hear.
Mr. Green, you need to get on that, will you?
Yeah, yeah. Chad's brother is always that way. Yeah, I guess there's no sense having that on.
And on Thursday, before I left, wanted to go over and check on our neighbor. My neighbor is a retired engineer. That moved over to Texas 2 years ago to retire. His wife had to go down to Southern California for 2 weeks to take care of her mom, to let her caregiver had to go do something. So her husband Nolan was healing. So she asked me, check on Nolan, which was okay. So I go over Thursday afternoon, run over and check on Nolan, see how he's doing, and he's just not Nolan. I was talking, couldn't talk really. Could answer my questions, yes, no, and I could tell his eyes just weren't right. And when he didn't talk, you could tell he really had to think. And I'm like, man. So I go home and I call my dad, and I'm thinking, Dad, could he have had a little stroke? And when I was talking to Nolan, he was, moving around, okay, so your arm's working. I didn't notice anything in his face, but he did say he had a headache. So I went over and asked my dad, what do you think? And he says, well, can you frown? He said, no. I said, I don't know. He said, well, go back over and talk to him and see if he can wrinkle his, if he can frown, he can wrinkle his forehead. He said, no matter how little a stroke you have, he said, you may not have the arm and the face and the speech, but he said, no matter how little of a stroke you have, you will lose your ability to. So I went over there and yeah, he could do that. All right, Nolan. I'm like, I don't know, dude. I said, you're going to ask him about his doctor. He says, well, I'm waiting for my referral to get it in writing. I said, when were you in your doctor? Last week. Oh, I freaking don't know what. Okay. So I go back home and my dad's like, man, you should take him in. Crap. So talk to Heidi, and Heidi says, no, let you guys go. She says, I'll take care of it. So she takes him in, and down the boards, you can't even have a visitor. You call them, they come out, get him out of the car, take your number. Okay, bye. That's the extent of getting admitted into the bridge. So about an hour later, she got a call that he was being flown to Spokane. Yeah. Well, about midway through, he got rerouted to Harvard. Well, he's going to wind up like Tracy. He's got some kind of brain cut. So, so your daddy retires 2 years ago. They didn't have airplane, they didn't have the airplane insurance. So they were just stuck there. $45,000 bill from the helicopter. You think you're good on that?
Yes.
Let me go back and see if I can, I'll let the judge, you just got the one.
Yeah, that'd be great. Where's that elements, bro?
What?
Elements, what one at the end of the L? I used to know where everything was at. No, that was common enough for Pasco to be a thing. There we go. Okay. How is it? Yeah, I mean, it's fair enough, because I worked with him. I guess when he started, he was he had left the city, he was a Richmond prosecutor. And so I handled cases with him back then, and then he left. And that's when Bell, or Tanner and Huey had Richmond working. When Tanner left, he was judge. Huey kind of, yeah, yeah. And then that's when Bell, Brown, and Rio took it over, and he kind of started doing private immigration work, private practice. I really haven't had to work with him at all since then. So it's been a long time. We got along fine. He was just a hard ass as a prosecutor. He would traffic cases. I was just telling someone a couple weeks ago when that whole dollar store this thing broke out in Kennewick. I was making a lot of donations to a lot of those things. I mean, the difference being Richland was the chair, but still, I had a DUI. I'm like, I'm donating $4,000 in cigarettes. $4,000. Yeah. They buy digital cameras for the police, to do things that are for police supplies. And it was all documented. The chair, not my Kennewick got lost. But I'm not talking that was back in 2004. But that's a lot of money back then. To get a reduction to an egg over it, you buy 4. All right.
Thank you. You may be seated.
Morning.
Good morning. Of course. Yes. Okay. Mr. Rio, can you hear us?
I can, Judge.
Excellent. We'll get you on the TV up here. Just 1 minute. We'll load the TV screen up here for the courtroom.
Just a quick little background here as to Mr. Value's case. He was originally on an SOC, and part of that SOC was his children, allowed for couples counseling. Since this SOC was entered, I provided proofs last week to the judge Stillwell that my client has completed his anger management. And he and his girlfriend have gone to couples counseling. And I provided a letter to Mr. Rio and to the court that essentially at this point, the counseling agency and counselor is recommending that these parties reunite so they can continue to work on the education tools that they've acquired and basically get them back into the home. So Mr. Rio last week was going to ask for revocation of the SOC, understandably so, because it was an infringement county charge. But we have a stipulation and agreement to revoke the SOC, and I've handed up a statement of defense on plea guilty with Mr. Valle, and I have gone over pursuant to the offer that Mr. Rio sent me yesterday and the conversation Mr. Rio and I had late yesterday afternoon. This is an agreed recommendation. Mr. Valle will change his plea, enter that plea of guilty, and then in exchange for the recommendation, Mr. Rio will agree to terminate no contact orders with parties and again get back together and work on tools they learn in council.
Okay. Okay, thank you. Mr. Rio, anything else you need to add?
Just the recommendation, Judge, is 364 with 362 suspended, doing 2 days, a $500 fine, $200 jail, sorry, $100 jail cost, $200 probation cost, loss of the right to possess a firearm, $100 DV cost, a $43 filing fee, attend anger management classes that can be online. And with that agreement with probation and the jail, I'm agreeing to remove the no contact order.
Okay. And Mr. Uvalde, is that your understanding of what the recommendation from the prosecutor is?
Yes, it is, Your Honor.
Okay, and do you also understand the court does not have to follow that recommendation? I could impose the maximum.
I do understand, Your Honor.
Okay, now you've had a chance to go over that guilty form with your attorney.
Yes, I have.
Do you understand the rights you're giving up by pleading guilty?
Yes, I do. Your Honor.
Okay, has anyone made any threats or promises to get you to plead guilty today?
No,
Okay. The other thing I need to ask you is that by pleading guilty, you will owe fines in this court. Do you acknowledge those fines and do you have the ability to pay for those?
yes, I do. Your Honor.
Your Honor, I looked at the document. I saw that you have 1 day credit. And so once we get there, I'll ask a little bit longer time.
Sure, okay. Okay, and I have been handed forward a certificate of completion saying that you successfully completed anger management treatment. So we will,
I just wrote on the plea form now that it was done.
I see that are we still monitoring? Even though that anger management has been done, Mr. Rio?
When was it completed?
August 13th.
Of this year?
Yes.
Yeah, then that's fine. No, well, so the answer is yes, it's a DV case, so it has to still be monitored, but, and he has to be risk assessed, but we won't be monitoring it for treatment.
Okay. So what I'm going to do is put that it's been a requirement of the sentence, and I'll just mark that it's done and include that in with the file so that probation knows that you don't have to go back and redo that, okay? Okay. Okay, so your statement is on June 8th, 2019 in Pasco, Washington, I had offensive and unwanted contact with my girlfriend and the contact was not in self-defense. Is that what happened?
Yes.
Okay,
And I'll ask you to incorporate by reference the affidavit of probable cause.
sure. I will go ahead and do that as well. This was a previous SOC. Okay, so sir, with that, I will find that you're making this plea freely and voluntarily and accept your guilty plea today, okay? I'm also going to follow the recommendation at sentencing. If we're pleading to the DV, do we need to have a firearms
Yes,
with this charge?
firearms forms,
Firearms
yes.
prohibition. Have you spoken with him about that, Mr. Jameson?
Yes, Your Honor, I can have you sign that. I've neglected to.
Okay. I'm going to hand you one more document to have you sign, sir. That's going to indicate that you understand that you, because this is a domestic violence conviction, cannot apply for or carry a concealed weapon license, no firearms possession or applications of any dangerous weapon, okay? Okay, I'm sentencing you to 364 days in jail. 362 of those will be suspended. Understand that while you are on probation for the next 2 years, you could have up to those 362 days imposed if you violate probation in any way, okay? Okay, your fine is $500. I'll give you, do we showing credit for the 1 day? Okay,
And
we're,
and would you allow him, maybe 4 to 5 days or so to do the other day? They have 7 children. He does work a full-time job as well as they are attending and continue to attend their counseling. So just if you can schedule it, well in advance that, come and do another day.
sure, I don't have a problem with that at all. The only thing is our clerks need to know a date certain right now that he's going to report. So if he can take a minute and look at the calendar, it can be any time within the next 60 days is fine with me.
I can do the
October 2nd. And there are certain times that you would need to report to the jail by, and Maritza, could you go over those?
6 a.m., 6 p.m., 9 a.m., 9 p.m.
So which one would you like?
Let's do the AM.
The 6 a.m.?
Yes,
Okay. And you picked October 2nd?
correct.
Okay, so that's the day you'll need to start your jail sentence for that 1 day. I'm giving you credit for the other day.
Thank you, Your Honor.
You're welcome. The fine will be $500. Jail cost is $100. Our probation still is $200, correct?
Correct.
Okay, $200 probation cost. There is a $100 domestic violence assessment, a $43 criminal conviction fee. And I believe that is it. That totals to $904. Sir, would you like to make monthly payments?
Yes, Your Honor.
And how much a month can you pay?
Probably as low as you'd be willing to allow your honors to get me with,
Sure, 25. I can do it $25 a month, and I can give you a few months before you start those payments if that's helpful.
That would help, Your Honor. Appreciate it.
You want to start them in November or December?
We could do this December, that'd be nice.
Sure, let's do December 1st, okay? Okay, $25 a month on December 1st will be the first payment. We'll go over the rest of your probation conditions. You'll be on probation for 24 months. I'm gonna mark that you are to,
And we'll be giving him a report.
okay, can we go over that on the record right now too, please?
It will be for Tuesday, September 8th at 2:30.
So Tuesday, September 8th at 2:30 is when you need to call into the probation department
Okay,
and meet with them there, okay?
okay, Your Honor.
Okay. While you are on probation, you need to make sure that you have no new criminal law violations, no domestic violence related incidents. Keep your address current with the court at all times. Be in good contact with probation. I'm going to terminate that no contact order that's associated with this case. However, if there's any other orders put in place, you need to obey those orders, okay?
and Your Honor, not to interrupt you, I just wanted Mr. Rio to know and Your Honor to know that Ms. Martinez, who has requested that this no contact order be terminated, I think no less than 3 times. She's written the court. She's been here in person the last time. She just showed up in the courtroom.
Okay.
So I want you to know, Mr. Rio, that she is aware now. I went and told her that it is being terminated as of today.
And
Okay,
we had a hearing last week where it was made very clear that she wanted this removed. And so that was part of my thought into negotiating this resolution.
okay, great. Well, then I'm glad she's here to see it done live and in person, ma'am.
Yes, thank you.
Okay, that's actually my next document. I'm granting this order to modify and rescind the no contact order. So that no contact order is no longer valid as of today's date. Be aware that it can take the computer system sometimes to get that updated. We'll get a copy of this. So I advise each of you to hold on to a copy for 3 or 4 or 5 days until it gets into the system, okay? You're welcome. Okay, I've signed that notice of ineligibility to possess a firearm. That was our last document. Mr. Rivali, do you have any questions for the court?
No, Your Honor.
Okay, good luck.
Thank you. I appreciate it.
Thank you, Your Honor.
Good morning, Judge.
Good morning.
And please either revisit or visit for the first time Emilio Vila.
Yes, I have that file.
Now, I indicated to Mr. Rio last night and this morning that I was going to be a little bit late getting back from Dayton this morning. And Mr. Jones, I think, had each of my clients sign and cut them loose, but I want to address the court on Mr. Rio's case, because there's some confusing conditions of release as it relates to his history and his facts that I'd like to ask for some relief on. And so maybe what I'll start with is where I think we're presently at in terms of the conditions that he has self-imposed and then imposed upon by the court. On August 13th, we should have confirmation of this. Mr. Avila had his interlock installed in his vehicle. And I believe that he provided proof to the court on that installation. That was in response to a communication that occurred between my office staff and this court, where it was advised to us basically that Mr. Avila didn't install the interlock device, that he would get a warrant for his arrest. And so we did in fact do that. Subsequent to that, then we had another conversation with this court through the clerks and my staff that clarified that apparently the order that was given to Mr. Avila on the day he was arraigned by State San Real was that he would have a scram bracelet installed as opposed to an interlock. And so while Mr. Avila did not remove the interlock, he also then attempted to impose or put in place a scram bracelet. I think that happened last Thursday or Friday. And again, it included a series of communications between myself actually at that point and your court clerks, because the original order had expired. And therefore we had to get moved to agree to put it on. So we did that because we believe that the order clearly stated. But we also had an underlying belief that maybe there was a reliance on some information at the time of his arraignment that might not have been accurate, or otherwise it was ambiguous enough that we should revisit it today. And so that's why I'm here on my way back from Dayton to simply address the court on its conditions of release. We're going to ask that you remove either both the conditions, or at the very least remove the scram bracelet that he got installed last week in his effort to abide by the original order. And this is where I think you'll have better information in terms of the discovery that I've been provided as it relates to its history. But my recollection, Your Honor, and it's just a recollection based on my conversation with the client, is that he got a prior charge of DUI out of, I believe, Oregon that resulted in a dismissed diversion. I don't know if you've got anything clearer than what I stated in front of you to review, or if Mr. Rio, you might be able to give a triple I report of some sort between last night and when I talked to him today. But so I'm relying on the fact that my justification of this history is accurate, that it has dismissed prior charge of DUI, and that's it. Then furthermore, as it relates to the facts of this case, it could or couldn't, I guess, give rise to a more strict condition being imposed discretionarily on their part. The allegations here are fairly straightforward. There was on a little side road, not an arterial, down here in East Pasco. The allegation is that my client, in navigating through this road while the police were stopping a vehicle on the other side of the road, moved around into the center or beyond the center of the lane in one of these little unmarked roads, and came in close to contacting the two standing officers that were there performing this other traffic stop. It led to an investigation for DUI. He was taken out of the jail, offered an opportunity to take a breath test or not take a breath test. He didn't take a breath test. He was taken to Lord's Medical Center for clearance for jail purposes. At the time, law enforcement decided that they didn't want to give a warrant for his warrant, and so it's an alleged standalone refusal. First offense DUI is in 7 years, arguably first offense DUI period. So I was thinking of the rules that govern the conditions of release being imposed in a circumstance like this, Your Honor, that in terms of his likelihood to appear, his likelihood to commit a violent crime while he's on conditions of release, and all of those other various subsections of the court rule that govern conditions of release, that even a PR in this case would be 100% reasonable. He is a governing member of some sort of the executive ladder of the Boy Scouts of America in the Tri-City area. He's otherwise a well-known and well-reputed individual around here. Whether this was a mistake or not, I mean, I guess that's something that we can discuss when it comes time to resolve this case. But at the end of the day, I don't think these two conditions are necessary. And so, actually, if you have consistent in front of you what I've already explained in terms of this dismissed prior DUI diversion, then I don't think the statute requires that you impose any of those alcohol monitoring conditions at all, except for the order them not to consume. And we can leave it at that. But at the very least, if the court needs some sort of protection for whatever reason it wants to articulate, then the interlock device would be completely satisfactory. It's a typical condition under the circumstances like this that the court imposes when there's anything imposed at all. So our request is to remove that scram condition. I can't tell you what the logic was in the judge originally ordering it in the first place, but I think under the circumstances it's unwarranted.
Okay. And to answer your question, Mr. Roach, I do not have any information on a triple I or from any other state history. Mr. Rio, do you have more information on that?
I do, Judge. He has a 2001 DUI out of Oregon that was a diversion, as Mr. Roach stated. The biggest issue, I wasn't present when the pro tem issued this order, so I can't tell you if there's been a change in circumstances. It doesn't sound like there's anything different than when the pro tem made his decision. There's nothing in the record, at least that I've seen, that says that he determined that this was a mandatory condition, and so he put it on because it was mandatory, and we should revisit that. The biggest piece here is the PC statement says that the defendant was in oncoming travel and came within 1 foot of hitting Sergeant Pettyjohn and 3 feet of hitting another officer. And so I would submit to the court that the court was at least trying to determine what's going to be the most appropriate thing to make sure that this defendant doesn't drink while out on release. And one of the things that the court has to consider is the interference with the administration of justice, which would be violating conditions of release. So it's not just whether they would have a new violent offense, et cetera. One of the things to consider is, will they interfere with that administration? The court decided that scram was appropriate, and so I'm going to ask the court to leave scram in place.
Your Honor, if I could just briefly respond. So I guess the confirmation is that 19 years ago, this individual had a dismissed DUI charge out of a different state. That, just as a technical matter, then certainly does not give rise to our statutory requirement that there be any condition at all related to alcohol monitoring imposed on him under the statute. So that's the first item that I think needs to be clarified, and I think it resolves favorably for Mr. Avila. The second issue, which I understand the city's motivation behind, is that, because this involved officer standing in the road, and that this individual is alleged to have come in close proximity to those standing individuals on the road, and those are officers, that there should be some, sort of pretrial accentuation or harsher conditions associated with that because of who was involved in this incident. And I'm not going to get into the politics of that, except for to say that the pretrial condition is not supposed to be considered a punishment at this point for any of the facts that were alleged here, but rather it's to secure certain behavior on the part of the defendant. And while the city has said that, that this is important for the administration of justice or whatever that sort of generic catch-all provision is in the rules governing conditions of release, I don't think that there's any suggestion here, especially based on the behavior since this incident, where this individual has done he's gone through several steps to make sure that he's cooperating with the administration of justice, even in the last week, that he's proven amenable to it. So everything that you have before you at this point in the presumption of innocence still being a constitutional value that we hold dear, I don't think that, quite frankly, I mean, if I wanted to be hardcore about it, I mean, there's really no reason at all that any of these conditions should be imposed. And whether or not, the earlier pro tem did this by way of a mistake, or if there was an argument made on the part of the city that wasn't rebuttable by me because I wasn't his attorney at that point, I don't know. But I don't think that it's unreasonable or even worthy of the amount of time that we've taken to discuss it on those, that under these circumstances, either of these things ought to be removed, or at least one of them. It just doesn't make sense under the circumstances. So I'd ask that you consider removing both of them because they're not required. But again, at the very, very least, remove the scram bracelet, which is incredibly punitive, unnecessary, and I don't think was imposed with the full appreciation of the prior history and the disposition of that prior history that we now have before the court.
Well, and that may be true or it may not be true. That's the thing we don't have. If we had the same pro tem, we would know that, but we don't. And so all I can tell the court is what I have today, and the idea, Mr. Roach says, well, we need to not really look at the facts of the case. Well, the facts of the case certainly should lead the court to determine whether he's a danger to the community or not. So my biggest piece is that I'm in the position of saying, Judge, the officers are standing next to the sidewalk on the other side of the street with a detained person, and they almost get hit by the car coming the opposite direction. So I'll leave it to you what you think is an appropriate condition of release.
Okay, well, I'm looking through the docket notes on here and comparing them with what the conditions of release were on August 10th. And I don't know what I'm missing, but I don't see where ignition interlock was actually ordered on these conditions of release. It's crossed out.
So.
And then, so it says have scram / ignition interlock, and ignition interlock is crossed out. So, and so it indicates to me that scram should be put in within 72 hours. Then the next line says remove scram or ignition interlock. That box was checked and then crossed out with Judge Villarreal's initials. So that indicates that was a mistake and he corrected that mistake. And so, Mr. Roach, why is ignition interlock installed? Is that something that your client did, or is that a DOL requirement at that point in time? Was that supposed to be from a court order?
It's a good question, and the best answer I can give you is that at some point early last week, potentially, well, somewhere right around the 13th, I would say, because that's the date that the installation took place. So somewhere a day or so prior to that, I would suspect, there was a communication through your staff to my staff that basically was a gentlemanly notice, you know, a collegial effort on the part of this court to communicate to us that if my client didn't have an interlock in, like within the day or something, that he would be getting a warrant because he hasn't satisfied the condition. And I had not even seen, I mentioned this to Mr. Rio last night, I had not even seen his conditions of release form to know, just in my own review, how to decipher whatever might be on that document. So I just went with the notice that was given to me through your staff that he needs to get an interlock installed. And so that's what we did, and he did it in very short fashion, like within 24 hours. But then after the interlock was installed, and I witnessed the conversation between my staff and your staff, basically, there was a clarification that, oh no, I mean, I'm paraphrasing this, right? But the storyline goes, oh no, it wasn't an interlock requirement, it was a scram requirement. And so then somewhere Thursday or Friday of last week, you know, it was made known to us that if he didn't get the scram on, then he was going to get a warrant for his arrest. So then we went and attempted to get the scram on, only to be turned away by Moon Security, which caused me personally to have to get involved, call your staff. We coordinated it. Moon Security got the green light to install it, and then we got it on Friday. So the confusion was that originally it was communicated to us that regardless of what's written on the order, that the interlock was the requirement, and that's what we responded to by initially putting the interlock in.
Well, and these docket notes indicate, sorry to interrupt, but I want to jump in here. These docket notes indicate that on 8/13, it was supposed to be a scram installed or a bench warrant. And then on 8/10, it says scram, or I'm sorry, ignition interlock is a requirement within 72 hours. And then on the 14th, it says Judge Stillwell signed the warrant for failing to provide proof that either a scram or ignition interlock has been connected or installed. So quite frankly, I think that the situation is very convoluted because I'm now the third judge to take a look at this and to address this and try to decipher this.
Sure.
And we have varying requirements and notes through our computer system and what I'm seeing. So my best judgment today is to take a look and address this case as general as I would just on my own. If this were just a case first time in front of me and look at these conditions of release. And I understand that's a complication because, you know, it's already been decided by Judge Pro Tem Villarreal, and Judge Stillwell had a hand in it. But at that point in time, I think that he was probably, at that point in time, I don't know that the clerk's office knew of the confusion of whether or not either one or both was supposed to be imposed. And quite frankly, looking at this document, it looks to me like scram was supposed to be imposed, or scram was supposed to be put in place 72 hours. I see no indication that there was ever an ignition interlock requirement. So I'm confused as to how that even got in, unless it's on the record verbally somewhere,
Right. That's what I
which it could be. So at this point in time, I want to look at this with the nature, the facts of the case, as Mr. Rio said. Those are very concerning as to what happened. But when we're looking at conditions released, looking at the history, the fact is we've got a dismissed diversion out of another state. So we're not, the court's not tied to the mandatory second offense requirements. So in treating it as this, I am comfortable removing scram and ignition interlock with the knowing that even though the facts are extremely concerning and egregious to this, if there's some sort of further information or a case law that comes back that says we do need to treat this as a second offense because that diversion in Oregon counts. I don't know that to be true, but if something else comes up that we need to treat that, I don't know that it's appropriate to further punish on a conditions of release. He's got $1,000 bail posted, and I don't know that if I were seeing this case as a first-time conditions of release, I would not necessarily impose any sort of scram or ignition interlock. So unless we have some information that Mr. Avila is violating those conditions, that he is consuming alcohol, I don't know that this is an appropriate case to initially start monitoring that without all those conditions. I think the facts of the case and the offensive of the nature of what happened that day is something that's going to come out more in sentencing at trial, and that punitive value will be handled there, quite frankly.
Correct, Your Honor. I appreciate that. And look, I'm sorry to have you be in the position of having to interpret what I also agree has been a series of ambiguities in the case. So and that's why I came back here rather than having Mr. Jones call it and stand here myself to discuss it with you because I knew it was a little nuanced. So, but I appreciate you taking the time to do it, and I'll serve that order on my client if you don't mind, Judge, and I'll expect, I guess, that the Moon Security will be alerted to the idea that he will be in compliance by removing that scram today.
Okay, well, here's what I'm going to do, and I'm going to write on this court order, and the caveat, Mr. Roach, will be that if there is something in the verbal record that's recorded, there's something that I don't know at this point in time that has not been discussed. If that comes back and Judge Stillwell or Judge Villarreal, because he was the first one, has a different position on that, it's not to say it couldn't be imposed at any point in time. Or, of course, if Mr. Avila violates the conditions, then that obviously could be imposed at a later date. But as of right now, from what I'm seeing, I'm going to order removal of both of those devices. I don't know that that's necessary or appropriate today.
And all other conditions, obviously, including the bail, remain the same.
Yes.
So, Mr. Roach, where are we setting this, since this isn't a case that should take very long? As soon as we have the ability to try a case or resolve it, I don't know, but there shouldn't be a whole lot to do on this case.
Well, I'm open to suggestions. What are you suggesting that we do? I mean, I don't have all the discovery yet, I don't think, but if we want to set.
I doubt you would. November 10th?
Yeah, that's fine. And I don't know, was there a waiver? I know he signed, he was here.
I have a waiver for October 27th, but we can
Let's
change
do that. No, let's do October 27th, Judge,
Okay.
Sounds good.
since that's what he signed for.
And I've written on these conditions of release, and I wanted to be clear that to try to leave somewhat of a paper trail on what our conversation was today. So I did write unclear what the previous court's ruling was regarding scram, ignition, interlock, remove both. Conditions, all previous conditions to remain. Parties are advised that alcohol monitoring requirement could be revisited if additional information is discovered from previous court hearings. So if it does come out that there's something else that was discussed that was in the recordings, be advised that that could be reviewed.
So again, I don't know if Mr. Rio or myself were present, so anything that did come up that was, that would be new information to me, and we can respond to it however,
Sure.
however it's required to respond to it, so no problem.
And we'll continue with the waiver to, what was that date, 10/27?
10/27.
Excellent. Okay, and we have our infraction tracking along with those matters.
Thank you, Judge.
You're welcome.
And I believe that maybe Mr. Jones also handed up one of the waiver, one of my application, call it in the docket if you want.
We likely already called it.
Okay, great.
Okay.
Thanks, Judge. Appreciate it.
You're welcome. I have Arturo. Do we have a Francesca Llanos Delgado present? Good morning. This is under Arturo Llanos Barquin. It's a no contact order request to terminate. Is that correct? Okay, let me take a look here and see. And are you you're Francesca, you're the protected party?
Yes. I am a brother.
Who is Katrina? And is she a protected party as well?
Yes.
Okay. I do not have any written document or information from you. Mr. Rio, would you like to hear from Ms. Delgado first?
Sure.
Okay, Ms. Delgado, why don't you go ahead and tell me why you would like me to lift the no contact order at this point in time? And I will just tell you that if you speak any facts about the case that could be used against the defendant, they were being recorded right now, the prosecutor's present, and so be aware that anything you say could be.
Well, I guess I'm confused, Judge. Why would we be advising her to not say things? That doesn't make sense to me. She's not the defendant. So the idea of we would advise people that they shouldn't say things that might be adverse to the defendant doesn't make sense from the city's point of view. They don't have the same rights with regards to remaining silent, etc.
That's
So
true.
from the city's point of view, we shouldn't be advising people, hey, don't say anything that might be adverse. But that's the city's point of view.
And Mr. Rio, you're correct in that, actually. I stand corrected. I know this can get, well, I'll just stop talking. Let's put it this way, Ms. Delgado, go ahead and tell me why you want the order lifted, and we'll go from there.
I would like to the order that we lifted because when we have it, I know we couldn't protect the order, so we got to get close to the house, but for us, we'd be able to talk to him and see him, we can be able to discuss what happened that day and to tell him if he can seek help and support him. That's the family that we are.
Okay. Okay, Mr. Rio, do you want to say anything?
I do, Judge. This is a case where the allegation is that the defendant was intoxicated. He has a prior 2003 DUI amended to negligent driving first. He's got a prior 2005 DUI deferred prosecution. Appears that was successful. He's got a prior assault for domestic violence from 2009. Looking at that, I can't tell exactly why it was dismissed, but it appears that was a dismissed case. He's on probation out of Franklin County for a hit and run unattended from 2019. The allegation in this case is that they're having an argument in a vehicle. He demands that they pull over. He grabs Francesca's arm while they're driving, assaulting her, and then assaulted the daughter by shoving her down in the seat, by grabbing her face and shoving her down. So the fact that I don't have any proof of any sort of treatment, anything that suggests that this won't happen again in the near future. We're just less than 2 months out on this case. It's in pretrial status, and I'd ask you to deny the request.
Okay. And Ms. Delgado, I can certainly understand your desire to keep your family together and to help Mr. Llanos Barraquin. However, for the reasons the prosecutor stated, I agree that it's not only is it too soon, it's just been a couple months, and I'm concerned when I look at that history there of those of the alcohol consumption, the charges and crimes related to that, and of violence. But I also see nothing on the defendant's part that is showing that he's actively seeking any sort of change in behavior. The court typically wants to see treatment, not only treatment, but completion or very successful compliance and progress made in treatment and an action on their part. I think it's a situation where it's, even though you want to help, it's not necessarily, you're not necessarily able to help at this point in time in those ways. Does that make sense? So at this point in time, I'm going to leave the no contact orders in place. I think that's the most appropriate thing to do. And if Mr. Llanos Barraquin does get treatment, does get help, does seek sobriety, if it sounds like alcohol might be an issue, if he does make those changes, then we can certainly come back into court and readdress those, okay? I can't hear you. What's that?
How could I, or what can I do so they can drop the charges on that too?
Okay, well, the court doesn't drop the charges. You can work with the prosecutor on, you know, your thoughts. But you just heard from him on his thoughts, and so be aware that a lot of times you don't have any control over whether those charges proceed and how they're handled at this point in time. Once that once that crime is charged, then it's in the hands of the prosecutor at that point, and the defense attorney. They'll work something out, however it works out. Okay. Now this case is next set for a pretrial on November 9th. So we'll see this matter back then. Okay. Thank you very much for your time. What's that? You may come to any of the court hearings and be in court, but but if he communicates with you before court, after court, in court, then that would be a violation and could give rise to new criminal charges for him. So be aware of that. Mr. Huey, are we ready with our kids in custodies? Okay, well, I have an Orlando Cameron in front of me first.
There's going to be a change between prosecutor's recommendation, 2 days in jail, $5 fine. We would like to plead guilty with that recommendation.
Okay. Good morning, sir. Yes, it is morning still. You had a chance to go over the guilty document with the attorney today? Do you have any questions about the rights you're giving up by pleading guilty? And you're pleading to that driving while license suspended in the 3rd-degree charge? Okay, you had some tracking infractions, a defective brakes, and a no insurance going along with that. We'll address those at the end of this, okay? You understand the prosecutor's recommendation is 2 days in jail and a $500 fine. The court does not have to follow that recommendation. I could impose the maximum allowed by law. Are you aware of that? Okay, has anyone made any threats or promises to get you to plead guilty today? And by pleading guilty, you will owe fines in this court. Do you acknowledge those fines and do you have the ability to pay for them? Yes? Okay.
Are you employed right now? What's the last time you were employed? How long have you been employed? A year. Okay, Dave keeps saying he's not been actively working for over a year or a year.
If I give you 6 months or so, do you think you can get a job and start working? Is there any reason why you cannot work and create income for yourself? Okay. Then in that case, I have no problem giving you a significant amount of time before these payments start, okay? Okay, you're welcome. Your statement is on August 31st, 2020 in Pasco, Washington. I drove a car while my license was suspended in the 3rd degree. Is that what happened? Okay, I'll find that you're making that plea freely and voluntarily. We'll accept that today. I'll follow the recommendation. We'll impose the 2 days in jail and a $500 fine. You don't have any credit that's accrued at this point in time. You're likely working on that first day right now, okay? You do get credit for the time you were booked in. They calculate it in 24-hour periods. So whatever time that was yesterday, your first day will be calculated the 24 hours today, okay? So your fines will be $500. You'll have a conviction filing fee of $43 and a traffic fee of $102.50. That makes your total $645.50. I'll set you at minimal payments of $25 a month. How about we start them in December? Do you think that's enough time? Or would you like to go in the spring?
Probably the later the better, because I still have my violation and then, I don't know, I don't know where to live, so kind of like.
How about, I'll set them for March 1st of 2021, okay? You're welcome. Make sure you do not drive without a valid license or insurance, no new criminal law violations, okay? Oh, thank you. Okay, so the infractions you had tracking along, I'll need to see that back. You had a no insurance and I think it was a defective brakes.
Be city's motion to dismiss the defective brakes and allow them to mitigate the insurance, Judge.
Sir, it's $553 for the insurance. I can assess that right now and you can add that on to what you owe. Or if you'd like to show proof that you have gotten your insurance, you can come into court in the next few weeks and show proof of insurance, and the court usually reduces that $553 fine down. Okay. So. Count 1, we're dismissing. Count 2. And that was 640. My total from the other one was 640. Thank you. $1,198.50 is what you owe, okay? Okay, I'm gonna keep your payments at $25 a month. They will, excuse me, they'll have $10 of that go towards your infraction, the 15 towards your criminal case. Once your infraction is paid off, since that's the lesser amount, then you will pay your entire 25 towards that criminal fine, okay? Okay. Jose Chavez?
These are probation violations, I think you have in the file, the probation sheet, and also you responded to it. There are 4 issues. I see the main issues are you have a new controlled substance case in Superior Court. And he also has, which is not listed on here, but I think it matters, he has a new driver license suspended his bud, phone to spring to bring. So I think the best thing to do is just to reschedule this to a probation docket, not bifurcate all the issues. And he's looking at 30 days, possibly. I told him if he pleads guilty to the driver's license suspended. And there's no set time on the drug case, but he might be getting time on that. So we're hoping that you set it for probation hearing. Those are on every other Wednesday, just to kind of track, see what happens to the subsequent violations and address the other two issues.
Okay. Do you know when you go to court on the driving charge?
You said next week?
That looks like it's over in Richland. I can double check here.
It is, Judge. It's September 11th at 9 o'clock in the morning.
So should we, let's set to probation docket after that September 11th day.
That's what we prefer.
And then, Judge, I'd just like to address conditions.
Sure. Let's go September 16th. Is that morning or afternoon? Sure, that'd be great. Thank you. And then, Mr. Rio, go ahead on conditions.
And I'm going to ask the court to impose that he have no criminal law violations, that he appear for all court dates, that he follow all probation orders. This is, I think it said the 4th violation. Or something to that effect. 4th probation violation. Now we'll be going on to the 5th one because of the new charges. There was a warrant for his arrest. And the only reason we have him back is because he was driving in Richmond without a license and insurance. So I'm going to ask you to set bail at $1,500 bond or cash to secure compliance with those conditions.
Okay.
Your Honor, none of the issues have been proven. Bond of the evidence, I think, is entitled to a hearing. We've already got 15 days in jail on one of the probation violations in the past. Generally, you don't punish somebody unless there's something proven, and he's denying all of these. So we're hoping that we PR him so we can come back to probation here.
I guess under that theory, Judge, if he continues to drive without a license and insurance, it won't matter because until he gets convicted, you shouldn't impose sentence. It's the fact that the court initially issued a warrant for his arrest because he was, the court usually sends notice to people. In this case, the court didn't do that based on a 4th probation violation, and he has new charges that violate his conditions. Certainly the court should set conditions that aren't just a PR.
Hang on a second. I think, did you say that it wasn't mailed notice? I couldn't hear what the prosecutor said. Normally these probation cases are mailed notices.
The court
This was a
issued
warrant.
warrant for his arrest because it was a 4th probation violation.
But I don't think that changes anything in the sense that he's contesting all the issues.
That may be, but the question is, what conditions does the court want to impose regarding him coming back? And I think the court can impose bail based on having new violations.
Generally, that doesn't happen. Generally, the sitting judge, if there are issues, they PR him on contested issues on probation and let them go to the probation hearing. That, I mean, he may very well later be getting punishment if he's found guilty with the driving license suspended and a controlled substance. But generally, you PR the city judge PRs and waits for those results.
So
Otherwise, he just sits in jail because he can't bail.
I understand that generally we PR for probation. Go ahead, Mr. Chavez, you want to say something?
Okay, when I got arrested when I went to Yakima County, and I sat there for 10 months fighting that case. The same day I got arrested for that case, that's the time that I got the possession, the controlled substance. Well, they didn't file until I got released. I came seeing you guys, and then they issued, they subpoenaed me so I can go to court. Well, they
Right now, I've been fighting with the trust service class.
Just understand that it's pending, you don't have. to-
Yeah, and this is the thing, like, I didn't catch that afterwards,
It doesn't matter.
That was from like 2 months
It
before.
doesn't matter when they charge you, if you get convicted of them, it's a probation violation.
And then.
Don't keep talking about that. They're just pending. I mean, I think there are delays, you know, how court works. Sometimes prosecutors file at a later date, but in the end, if he is found convicted of that or pleads guilty, he knows he's a probation violation, but our staff is right now, he's not yet been convicted of that.
Okay, I understand that you're denying that you committed those new charges. I understand that. The possession charges and everything of that nature. What I'm looking at, I'm reading the report right now for your driving while license suspended third charge. That quite frankly is, as Mr. Huey stated earlier, has a significant, not necessarily a more significant, but a mandatory sentence if you're convicted of that charge on the probation here. So I'm concerned that you are driving without a license, and I'm looking at something from September 1st. It's a police report telling me that you were arrested. You also, when you were arrested, you had 2 warrants, one out of DOC and one out of Pasco, this warrant right here. I can tell you my biggest concern is that if I release you without any sort of bail, you're not gonna come back to court. I have so many warrants on your history, so many warrants on this case. You don't show up to probation. You were ordered to do everything from a victims panel to contact probation. And the allegation at least is that you haven't done that.
No, I called you on that, I called, and John, this was the ring. I kept on calling from the day before. I kept on calling. I tried to check in with prevention, they were not answering. I tried calling for the victim panel and all that. You know, like I'm trying to do everything. I got a job, I'm working landscaping right now. That's, you know, I'm trying to do what I gotta do. That was opportunity to get this over with.
Okay, well, right now, I'm going to grant the city's request to impose a $1,500 bail. I think that's appropriate, like I said, based on the fact that you have not shown that you come to court when you've been summoned. So you can post that, and then you can take care of your other matters, or we can hear this. It's cash or bond, yes. Yes. All other conditions, no new criminal law violations, do not drive without a valid license or insurance. And your next court will be September 23rd. That's when we'll handle these probation matters. Okay, Sean Hamilton. Good morning, sir. I said, good morning. Sir, you're here on a destruction or removal of property charge. Is it your intention to plead guilty to that today? And you had a chance to speak with the attorney today? With this gentleman, the attorney? You spoke with him and it had all your questions answered? I can't hear you very well, so we might have to have you speak up too. Any questions about the rights you give up by pleading guilty? Okay. The prosecutor's recommendation is 4 days in jail, 0 days suspended, no financial penalty of any kind. Is that your understanding of what that recommendation is? Okay. You also understand the court does not have to follow that. I could impose the maximum. Has anyone made any threats or promises to get you to plead guilty today? Okay. And I see there's no financial penalty imposed. That tells me that we don't actually, I don't even have to ask you the question about financial obligations. Tell me, sir, it looks like this is an Alfred plea. It did occur on August 31st, 2020 in Pasco, Washington. What you're telling the court is you do not necessarily believe that you're guilty of destruction or removal of property, but you think that if this matter went to trial, the prosecutor would present sufficient evidence and a jury would convict you of that charge. Is that what you're saying? Yeah. Okay. And does the city want to incorporate by reference the police report?
Please, Your Honor.
Okay. Okay, and I think that is sufficient as well. I agree with you, sir, that you would likely be convicted of that. So I will find that you're making this plea freely and voluntarily and accept your guilty plea today, okay? Regarding sentencing, I'll follow the recommendation. We'll impose the 4 days. It looks like you have 1 day of credit, so we'll count that for you. 3 remaining days to serve, okay? You're welcome. And that is all for you. No additional obligations. Just make sure you maintain law-abiding behavior, okay? Correct. No friends. Oh, this goes in his name too. Thank you. Austin Smith?
Should have keep file, Your Honor. This
Oh,
is
yes.
these are probation violations or fail to jail. These after 83 days, you know, he's admitting to not putting himself in at that time. Total additional punishment for not showing up. He would like to give an explanation as to why he was supposed to get less than the additional time the prosecutor for rape correction. He has to
prove to the court that I was trying to do something, I'm trying to move forward, that I don't have enough.
Okay. Well, I appreciate you keeping in contact with probation and attempting to do the other portions of your sentence. Unfortunately, sir, it's a big deal to miss the jail portion of the sentence. What, can you repeat again the additional time?
I know I sent the file, looked at it.
Your Honor, the recommendation from the city is 30 days on the matter ending in 476 and 75 days on the matter ending in 272. He was to do 20 days on the 476 case, so we're adding additional 10. And he was to do 63 days on the other matter ending in 272. So we're adding about 12 additional days. So truly, we're adding 22 days for not coming and doing jail on these cases from just a small, June, where he didn't turn himself in. He also has a warrant on a March Franklin County assault case. So I would ask that he have to serve it now, please.
See where that one.
I told you about it. I did frankly.
Okay.
I don't have access to jazz. Can you look at?
I can look that up in a minute.
And the warrant, I'm only bringing up the warrant with regards to having to serve it now, not because he should be getting a penalty because of that. I'm just saying he shouldn't be given any extra time to report it on a future date.
He's
Okay.
not requesting the extra time. I told him the warrant. I told him I didn't know anything about it.
I can look it up here real quick. And sir, I think that the additional days that the city's requesting is very reasonable. There's a lot of courts where you would get a significantly higher amount of days based on not doing jail time. So I'm going to impose that time. It'll be a total of 30 days to serve. It'll take me a minute to write this out. On the cause ending in 476, you were originally ordered for 20 days, correct?
Yes.
And Your Honor, on the driving license suspended, and we closed that case. That's generally not a probation case. I think it was just open because of the jail. Since he has served his jail, we asked that to be closed. The other one, the violation of court order, I think that probably stays open.
Any objection to that, Mr. Rio?
No, Your Honor.
Okay, we'll close probation on the driving charge. After you've served that sentence, sir, then that will be all of your obligations on that matter, okay? Okay, so. Is this the right form for this? I don't see the usual spot where I put failed to serve original time.
So they admit the violation. So I have prior sentence and then.
Will you just mark it for me, please? 63 original sentence, total of 75 on that one. Okay, so I can let you know about that Franklin County case. That was, you're supposed to be in court on August 26th. You did not come. They issued a $500 cash or bond bench warrant.
August 26th.
Correct.
How many additional days? How many of the 63?
12 additional days for a total of 75.
I didn't receive notice for that.
Okay, you have an attorney on that matter. It is,
You're gonna go to court. Is that
it's Miss Presler. So talk to your attorney about that and let her know. That's a different court than us, but they'll be able to take you right over there. Franklin County.
Don't talk about it anymore.
The other thing, I have motions and orders for fingerprints on the,
Yeah, and I'll take care of it.
and we need to do
Yeah,
this?
I know
Okay.
how to.
So you want me to sign this?
Um,
Do you want me to sign both of them or just one?
Just one. Is that good?
Yep, perfect. And then will you do this one for me too, please?
Sure.
That is a original sentence of 20 and we need to add 10 for 30.
And this one continue probation.
Correct. Continue probation on that.
You adding how many days to?
10 on top of that one for a total of 30. There's the, these two are his files. Thank you, Martha. That's it. That's perfect. Thank you. And I think that's our docket. Anything else?
No, Your Honor. Thank you.
Okay, thank you.
Have a good day.
You too.
I just wanted to ask if there any type of programs I could do in jail for like interviewing or anything like that.
That's a good question. Ask the jail.